Welcome to Created IP and this episode called Who Owns It? My name is Kerry Bynon and I am joined by
Emma Clarkson,
Grant Hayward,
and Alice Wright.
Welcome everyone.
Thank you.
Hi, nice to see you.
So let's start off, if we may, by talking about what is, briefly speaking, IP.
I think first of all we need to tell our listeners
we do.
what we mean when we talk about what we're owning, because obviously you've got IP rights,
Yeah.
and what we want to know help our listeners establish is who owns the IP rights.
Yeah.
And when we talk about intellectual property, IP, I for intellectual, P for property, we've got some basic types of intellectual property, like trademarks, designs, copyright, and then I guess getting more into it like patents, but they're kind of more technical stuff. So you've got designs, which cover like aesthetic looks of products. You've got trademarks, which protect brands. We've got copyright, and like copyright is basically anything you create, anything that you create in your mind and you write down and fix into like a fixed format, permanent form. That's copyright, and that you don't even have to register that. It just
I was about to say the main thing we kind of want to get onto, or at least I want to get onto, is registration versus non-registration and how you still have an ownership of an IP right.
Yes.
Even if you haven't registered
Exactly.
certain rights. And it's
And then you've got
patents, which
tech.
in
Like
basically
know-how.
inventions.
Yeah, exactly. Trade secrets, confidentiality,
all,
those kinds of things.
all that.
But all of those rights, they have an owner of them, and a first owner we talk about in IP, and that is the person that creates or invents, and that is known as the first owner of the intellectual property right, and that will vary based on a few things but basically according to the law on what the law says about the first ownership of each of those rights.
So if we take the employment context, for example, what's the situation there?
Well, in the UK, if you are an employee and you create intellectual property in the course of your normal employment, then that, for example, you're a designer and you're employed to design by your company, then the intellectual property you create as a designer will not vest firstly with you, it will revest with the company who is employing you to do the design work. And that's kind of the main way that the company or the employer will assume an employee's intellectual property.
So I've employed you to do a job, you're doing your job in your normal course of your duties, you create something, I as the employer take ownership.
Yeah, that's right.
And you would make sure that you've got that in your employment contract quite robustly.
Obviously, or because the biggest disputes happen when someone creates something during their employment, but it's not specifically their job to do that creating.
Or they claim they've done it outside of working hours. The last thing you want to do is have a situation where an employee goes and creates a patent application, for instance. They're an inventor of it. And the owner of that is not you. Essentially, because it could be the difference between 100,000 lost revenue because someone else is essentially benefiting from that IP that is fundamentally yours.
Yeah.
Of course. I mean, I think that's one thing that when talking about ownership of IP, you really need to make clear is that the law itself gives you the principle, but that you can rely on. But it's always a good idea to write down and put those requirements in the contract, because there's various criteria that needs to be met to determine that the work or the piece of work that is intellectual property is owned by the employer. And if you set that out in your contract so it's clear to the employees, it's harder to dispute that the company owns the IP.
Thinking of it from like a registration point of view, so I'll go back to patents in particular with you've got your inventor and you've got your applicant, and they don't have to be the same person.
Yeah, so let's explore that. So who's the inventor and who is
so in an employment situation you would generally expect, the inventor is the person who made it, but the employer,
so if I created some tech and I wanted to apply, if my company took ownership, I would be named as the inventor.
So there's that recognition there. But in terms of enforcement, like you have to think who's actually going to enforce these rights once they're granted. So
that's where the employee
that's
comes
where
into
it's
play.
quite interesting to see the fine line between inventorship and ownership, because what you then go on to do with those IP rights can be very different.
Yeah. And I think we've all seen cases, haven't we, where particularly with startups that have exploded and they've done really, really well, and they didn't quite follow the usual, let's call it the usual process. And so sometimes rights aren't in the right name, are they?
Yeah.
I mean, that's not just in situations where it's employees. That can be where you've got a sole director shareholder who unfortunately hasn't distinguished between themselves and their personal capacity and themselves and their business capacity.
Because it was their baby and they...
we see
and
that a
even though
lot.
they've got a company opened, and their intention is, when you ask them, is that the company would own it, but they put it in their personal name, not understanding how that distinction actually really makes a difference.
Well, we've all been there with a meeting with a client. They're like, I do this, I do that.
That's the thing.
And then you break it down, you're like, who is I? Who is we?
In that situation.
And then you break it down and it's, the company and it's another company, it's a subsidiary and,
So then in that situation, then you have to go back and correct it then, don't you?
Yeah.
So you're doing all your, your assignments.
Look, I think the important thing is, as a trademark attorney in particular, is to bottom out who it should be the owner as one of the first things. It's like
before who is.
before even what they know they want, it's establishing who is going to be the owner. And before we open a file, even what we will ask is, okay, so who's going to be paying for the work? Is the person that's paying for the work going to be the owner of the work? And a lot of the time, it will be.
And it's not until you ask those questions you actually find out, and
But then
some people just think it's obvious that because it's me, I'm doing it, and no, because you can have so many different legal personalities under you that they can come back to bite you.
The secondary point to that is not only who owns it, who's going to use it.
Yes.
Because you can create all sorts of problems for yourself later down the line if you can't prove use to that entity.
Yeah.
You don't want to be relying on implied licenses and all that.
So this is quite interesting. So we've discussed the employment situation, who owns it in that context. But what about when you're dealing with third parties? So you might reach out to a designer, for example.
Well, I think that's really important. I mean, for example, okay, you are a company and you haven't got the funds to employ a designer in-house. So how would you get those skills? You probably go to a contractor and outsource it, basically. And what's interesting is if you're outsourcing something or you're paying a contractor who isn't an employee, the first principles of employment ownership don't work. And actually you have to have an agreement with the contractor that says that any IP that you create will be owned by the person who's paying for the work.
Because people assume that, don't they? They do assume if you pay for it,
because you're paying for a service.
But you might not necessarily own it. You might just have a license to use it.
And then you get into all sorts of arguments over using outside the license. I mean, I can think of examples where companies got themselves into, £300,000 worth of breach of license charges because they thought they could use the emitter X and they used it for Y. And these are honest mistakes, but at the end of the day, it doesn't matter how honest they are and how confused you got. If the writing on the paper says you can use it for X size only, you've got to use it for that size.
And when you're dealing with creative works, like what you're going to use them for is forever changing, isn't it? You want full ownership of that so that you can exploit it how your business wants to.
And I suppose the other angle of it as well is if someone's, say, you've employed a contractor to create said works, but they actually want to use, and they license you or you own it. Actually, what if they want to use that themselves for their own marketing purposes, for instance? Here's a piece of work I did for someone else. You need to have all of this worked into the contract, don't you?
Which is quite interesting. So moving on from we want to own what we essentially pay for, let's talk about licenses. So if I'm not so fussed about being the owner of the legal work, I just want the right to use it, I'm asking for a license. What have we seen? Any pitfalls there in licensing?
Remaining in control. In any license agreement, you've got a right owner and someone that's wanting to use the right. And I think if we think about it from the position of the person that owns the right who wants to do the licensing, what you've got to be really careful of is making sure that you, as the right owner, you remain in control of how the licensee uses those intellectual property rights, because you don't want to be perceived to have abandoned your ownership by letting the licensee do what they want with your intellectual property. So it should be regulated, and there should always be in a license some kind of governance or provisions that that makes it really, really clear what the permission, because a license is effectively a permission to use someone else's IP. And when you're doing a license, you really need to be clear about what you're allowing the other party to do. And it's important as the owner to think, what is it you do want them to use it for, and what is it you don't want to do.
Particularly with sub-licenses as well. That's where you can get into tricky areas, because you can set a term on your license. If you let them sub-license, that's a loophole for them to.
I mean, there's lots of arguments, like there's all different kinds of licenses that you can use.
So should we just explore that a little then? So what's an exclusive license and what's a non-exclusive license? And just one or two pitfalls of each.
Well, an exclusive license is really interesting in the fact that if you as an owner grant another party an exclusive license, literally they're the only party that can use those rights. You as the owner don't have an automatic right to use it. You've given it all to the licensee.
So the commercialisation then rests with the person that you've licensed it
to, and not yourself.
So you need to make sure that in that situation then that you really understand the pricing model, what's the license fee.
Exactly.
You want to be clear with that commercial model, and that's how we're using it.
And then you also have something called a sole license, and a sole license is when you as the owner can use the IP, and then you would grant one other party rights to use the IP. So you can continue doing your little bit on the side, they can do their little bit, and it's governed by the license agreement terms. And the last kind of license you have is a non-exclusive license, which is basically you can grant multiple licenses to many different parties on various different things under various different terms, and you can continue doing your thing at the same. So it's a different consideration. I mean, as a licensee, you will always ideally be looking for some kind of exclusivity so you can protect your business. But from the point of view of the owner, a non-exclusive license probably means that you can offer the same license to different parties and then make more money off that.
As if you end up fee pricing to one company, but that company has 3 subsidiaries, but you're licensed and they've got permission, but you treat it as just one, you're out of pocket.
Yeah.
Indeed.
So it's
your royalty. Your royalty clause is going to be really important.
One of the things that's always kind of, as an attorney myself, I have a knowledge of licenses. One thing that's always been a grey area for me is if you have an exclusive licensee, are you allowed to grant them sub-licenses? And if you grant an exclusive licensee sub-licenses, does that still make it an exclusive license? Because if they're licensing it themselves, then they're no longer exclusive.
But they have the exclusive rights to sub-license. That's a really technical point.
Sorry. Maybe another day.
You think you got the answers to that, and then you're back at square one, really, because you kind of, the answer's within itself, but it's not. And,
but maybe that's something for a different day.
Yes. Whole episode on that.
But I suppose the other kind of thought process on that is kind of inside companies themselves, in terms of if you've got ownership of IP somewhere, who's using it, where that goodwill's been attributed to, where there's so many interplays there, whether that's been assigned somewhere, whether that's
intra-company licenses are actually really, really important, not just for use, but also for tax purposes. Because obviously, if you're a parent company and you own the IP at the top, you want to grant all your subsidiaries license to use the rights, but the use will be attributed back to the owner through the license. But also, you can then argue that if you've got lots of difference, that the profits relating to the license through the license agreement can be attributed back to the parent company, and that can make a more effective tax model.
So we're hearing, it's the legal exploitation of rights, understanding that, making cash through getting the right royalty or exploitation model, and also thinking about your tax.
Yes, yeah, it sounds good. Yeah.
And that just comes back to your IP structure should be in line with your business structure, and your IP strategy should be your business strategy.
So I'm going to put you on the hook now. 3 top tips from each of you, please. And I'm going to
3
start.
each?
Yes, 3 each. 3 top tips. I'm going to start, Grant, with you.
Oh.
I love
That was
It is
me.
cruel.
That is cruel. 3 top tips on just your IP strategy, is that?
Yes. Yeah, actually, well, now,
IP
just your
ownership,
Yeah, I would. Yeah, my number one is always, make sure you know what you've got and who owns it, because and that's basically 2 in 1. Because
I counted as 1, but okay, I'll do it. Come on with one more. Come on. One more.
And I would just say what you can protect, and that can be registrations, or it can just be documenting what you have, dates, and use.
Cool. I like it. Right, let's come to Alice.
Ooh. Yeah, I think I'm going to pick up on Grant's point there. I think my top tip would be ownership. Whatever the ownership of anything you create, put the ownership position in writing. Because write it down. I mean,
So don't rely on the law.
Don't rely on the law.
Position.
I mean,
Document it.
all in the UK, ownership provisions of IP can be varied according to contract. So always have a contract to tie down where the ownership of IP lives, and have that in an employment contract with your employee, with if you're working with contractors, with the services agreement, always have some provision about who owns the IP. So
Well, I'll take that as 2 because you refer to employees and subcontractors. Last one then.
don't always assume that you know who will own the work, because as I said, it's not necessarily always clear who the owner of the IP is.
So take some advice if you need it.
Yeah, take advice.
Right, good.
Ask us.
Under pressure now, come on.
I know, get left with the ones not already said. Well, having a contentious angle to my answer is, once you know what you've got, you've protected it, you need to enforce it.
Yeah.
So it's always checking the market, checking your competitors, checking no one's passing off, checking off that no one's using similar marks and trying to benefit
That's a
from
really
that.
good point, because you can lose your rights if you don't police them, can't you?
Exactly.
Yeah.
Exactly. So once you've got it, enforce it so that you have the ability to carry on enforcing it.
Okay.
Is that 1?
That's 1.
I haven't thought much
Come on, I'll let you off with another one. Just one more.
Yeah, and I suppose the next thing with the ownership is making sure that you're, when you come to enforce it, that you don't have any arguments for non-use because it's not owned in the right entity. So that's one of the reasons that you really need to make sure that you know where it is and who's benefiting from that in terms of company structures and things like that.
Okay. So if I was to summarise then, I'd say it's all about your ownership.
Yeah.
That advises everything else. Okay.
Yeah.
Cool. Well, this has been,
100%.
it's been a really good discussion. Thanks
I feel like
everyone.
there's so much more we can do.
Yeah, no. I mean, we didn't even get into the patents and the
No.
and the fact that in different countries different laws apply, and
Worldwide companies.
Yeah.
Well, subjects for another day.
Yeah, exactly.
international IP. We've definitely got to do something on that.
Absolutely.
Yeah, well, thank you everyone for contributing. And that's it from Created IP.